Proceed. Thank you.
Good morning, Your Honors. My name is Robert Johnson from the firm of Gray Robinson, representing the appellant. We are here today discussing matters that really started in 2002. And that's when the decedent, Jerome Rudin, with the assistance of 3 lawyers, one in Ohio, one in Pennsylvania, and one in Florida, executed documents to implement what was described by the Florida lawyer as Mr. Rudin's estate plan. He wanted to roll over his IRA into his pension plan, which he formed in 2002. He executed in 2002 the Fordham Investments Retirement Plan, the Fordham Investments Retirement Plan Trust, and established Fordham Investments Inc., in which he was the president, his spouse was the vice president, and his Florida attorney, Mr. Nemec, was the secretary.
Is there a tax advantage to the rollover?
I don't know the answer to that. Obviously, he made a determination that this would be the better place, with the guidance of his lawyers, to place the money that he had in the IRA account.
I'm just curious as to why that is an advantage.
And I apologize, I'm the litigator and not the tax lawyer, and I don't know the theory specifically behind that, whether it be substantial tax savings for him over the years. Again, the problem that we do face now is that if in fact the lower court ruling is correct, that would then, the rollover would then be income to Mr. Rudin in 2002. And that's what our major concern is here today. And in addition to that, what has happened is the plan that Mr. Rudin has put into place, signing all of these documents, would be destroyed.
The question, though, here really, it seemed to me, and I don't mean to get to the point, but I'm that kind of a guy, if you don't mind. I just kind of like to get to the point. The point really is this a viable corporation? Because a corporation must be viable to sustain the tax advantage. And the question is, does a state probate court sitting in its probate jurisdiction have the right to make that determination, or is it undermining the letter ruling given by the IRS? And I think those are separate issues. I think a state probate court sitting with probate jurisdiction exclusively has the right to determine what assets are in an estate and what assets are not in an estate. And it also has the right to determine, is a corporation, was it viably formed, is it operable, is it really a corporation at all? And if not, then the assets of that corporation are not inside that corporate entity. So the issue, as I understand it, you've taken the position is, how could a state court sitting in probate undermine the IRS's letter ruling, which said this is an authorized plan, this corporation, and it was a qualified letter.
Correct.
At the time, it said the corporation, for the moment, is fine. And then we sort of have this process later on where even the decedent and his wife sort of talked to Mr. Nye, or communicate with Mr. Nye, and said, have we done enough to sort of with this corporation? And he said, no, you haven't. You need to do more. So why don't you take it from there? To me, that's where this whole thing is centered.
Right, and one of the problems that we all have in this case is this corporation was set up by the decedent in 2002. He was the president, he was the employee, and he put what we contend is his plan into action. He had an employee, which was himself, although that was an unpaid employee. He had a business plan. He was going to be bringing clients in and hopefully generating some business with this entity. Ms. Rudin has testified that she was doing some tax returns. The tax returns for outside individuals, which were put under the umbrella of Fordham Investments. She was a CPA, yes. And what we have is the corporation every year filing for its annual report. It filed its tax returns. In those tax returns, It listed the business as investments and portfolio management. Essentially, it appears to devolve as that they were managing the money that was held in the plan itself.
The tax returns filed late after someone passed away, after Mr. Rudin passed away, they were filed late to
Correct.
make that, okay.
Correct. Yes, those
They
returns
were
were
not
filed
annually.
sometime after the passing of Mr. Rudin. And again, in this case, they were also filed annually. Return reports with the IRS, those are the Form 5500 forms by the actuary who was reporting on the entity itself and the plan itself. Now, we contend that under the case law we cited, even if we put aside the issue of whether or not the state court had the authority to come in and make these interpretations of federal statutes, that this was a company that was engaged in commerce certainly sufficient to meet the standards that are imposed by the IRS. And that's where we get to the difficult.
So it was formed in terms of articles of incorporation, bylaws. It was paying the annual fee. It had elected officers and directors. Did it file a tax return itself?
Yes, that's what is pointed out. Those tax returns were filed on a yearly basis, but didn't get filed until 2006.
I misunderstood. I thought you said that she was doing sort of an independent tax practice for others under this umbrella.
So there's sort of two
things happening.
Two things happening.
Right.
So they did file the tax returns, but she was also doing some business. They were looking for some business. Originally, the intention was, and again, this is all more in the nature of hearsay because we don't have the decedent here to tell us what his actual plan was. The wife has testified that when this was put in place, they were hoping to generate income for Fordham Investments by bringing in investors to the NIGA. Now, I will concede, did that specific business ever get off the ground and generate income? No. And the tax returns reflect that there was no income. But as we've indicated in our filings here in the cases that we've cited and the tax decisions, it's not necessary for Fordham Investments to be in the active practice of a business. The real concern that the IRS has in these cases is where an entity is set up and then that entity somehow goes defunct. In that event, there's no one to administer the money that's held in the plan. So in this case, you've got $2-3 million that's held in the plan, the business disappears, there's no one to make the distributions under the terms of the plan. Here, that's not the case. We had Mr. Rudin, who was available to do that throughout his lifetime, and then subsequent to that, we had Mrs. Rudin, who was available to do that. And the plan simply continues on until we had this ruling 10 years later, where the court comes back in and sort of what we think second guesses what the IRS would have done here. It really should be, as we contend, a determination for the IRS. The respondent, or the appellee here, has contended that this was a sham corporation. I don't think that they can meet that standard in any way, but if it was a sham corporation, that should have been reported to the IRS. The IRS could look at this issue.
Does the record indicate whether anyone has asked the IRS during the pendency of this case to make the determination you suggested?
No, Your Honor.
No.
There's also an argument here that was made to the lower court about regular contributions being required. We don't believe under the IRS regulations that we've cited to the court that regular contributions are required. It can be, and the IRS has accepted, where there's one rollover that takes place, and that rollover stays with the pension plan. There's an argument that was made to the lower court that there was not permanency here. They have cited a number of cases where the plan was set up and then discontinued after 2 years. That's not the case here. The plan has continued. You know, the actuaries have been filing reports. There have been disbursements from the plan. And we think that, you know, this was, again, a summary judgment that came up. And there's certainly evidence in the record in dispute as to the operation, whether there were employees. And we also have submitted the affidavits of at least 2 of the lawyers who were involved in the preparation of the plan. Mr. Nemec, unfortunately, he was really sort of as an accommodation here, the local lawyer, but Mr. Nye has indicated he was involved in the plan from the very beginning in advising them, and that in his opinion it had met all of the IRS requirements. And we certainly think that that at least creates an issue of material fact that shouldn't have been hurdled over by the lower court. And one of the additional problems we've had here is that the lower court wasn't given an opportunity to even review the plan itself. Now, my typical practice as the defense lawyer is when someone is moving to have a court interpret or disqualify a document and they don't provide that to the court, I didn't provide it to the court. Now we've got some problems because all of the parties have sort of, including the judge, has sort of fallen into citing from the plan itself, and that's not even before the lower court. And we think, again, it's important for the plan to have been before the lower court to follow through on our additional arguments, which are...
Well, I can understand that, you know, it is surprising the plan was not there. It was surprising that it was not read. But is it really material to the key issues that are teed up here?
Yes, and we contend it certainly is, Judge, because you know, I'm in a very difficult position because I've got the plan, and I think there are provisions within the plan that talk about IRA rollovers, define employees, talk about the administration of the plan itself and what can be done by the administrators in accepting the employees, but we don't really have that. Now the court, again, cites to that the plan itself, and one of the major arguments that we've made here is in order for the appellee to get over another threshold here, which is there's a plan which we contend is in place, and that plan accepted the IRA rollover. The plan has specific language in it that talks about who the beneficiary of the plan is. I thought perhaps one of the reasons that they didn't put it in the record was so that we wouldn't get into who the beneficiary of the plan would be. But even if we are not going into the plan itself, federal law requires that unless there is a beneficiary designation done by, in this case, Mr. Rudin, and a waiver by the wife, under federal law, those monies should go to Mrs. Rudin. And we go back again, even under Florida state law, there was a trust set up. Mr. Rudin executed the trust. The monies flowed into the trust, and the trust governs what should be done with the money. And the trust says the monies must be dispersed according to the plan. So we're sort of left in a, this is one of the summary judgments I've handled where there is so many issues out there that it clearly seems inappropriate for the court to have ruled the way it did at this, what we contend is sort of an early stage in the litigation. I know the litigation has been pending for quite some time, but we were here before the lower court on merely an objection to the inventory that was filed. And we don't believe that all of these issues were appropriately teed up before the lower court, so that the lower court could have made an informed decision based on all of the facts.
I would advise you that you are at 15.
Oh,
It's your time.
Judge.
You can keep going. I just
No,
don't want you to...
let me try to reserve my 5 minutes and come back up again.
Good morning. May it please the court, I'm Wayne Thomas with Ackerman LLP, and with me is Jason Morgan, my associate. Your Honor, I would submit that Judge Conomo made exactly the right decision in this case, because there really weren't any factual disputes with regard to the matters that would go into the decision of whether this was an appropriate plan or a valid plan under the Internal Revenue Code. Or
here's one of the problems I have with his judgment, though. His judgment specifically says in the conclusion, since the plan did not meet the requirements of a retirement plan qualified under the Internal Revenue Code section 401, the plan is not a trust under Florida law. That, I have a hard time understanding how a state court circuit judge can take a position like that. It is in effect overruled the IRS. And if the IRS letter ruling or the qualifications of this plan under their regulations is an issue, isn't that certainly an issue for an administrative resolution in the IRS, probably a tax court issue? How on earth does a sitting state court circuit judge take that position?
Your Honor, the judges do that all the time in this state. Matter of fact, this court has essentially done that in the Deeb case.
Well, Deeb's a fair bit different, isn't it? I mean, all that case stands for, as I read it, is if you have an inherited pension fund, then it's not going to be immune from garnishment. It doesn't get into whether or not it qualifies for tax or not. And I guess dovetailing off what Judge Morris said, my biggest concern about your position in this case is you kind of have an upper story and a lower story. The lower story being, is this corporation viable? But how is that ever divorced from the concept of the only reason to address that question is for IRS purposes? I mean, that's the only issue that matters.
Yes, but it's exactly the same issue that does come up within the context of Chapter 222 cases when you're determining the exemptions of either plans or funds. It's how it came up in the Deeb case. It's how it came up in the Blaze case, which was a Southern District of Florida case in which a debtor had taken improper loans from his plans, and there was an initial determination letter, just like in this case. And in Blaze, the judge there said, well, we have to defer to the IRS because that's what was said in this Youngblood case, which is a Texas, well, it's actually a Fifth Circuit case. Youngblood had said that under a similar type statute that the state courts should defer to the IRS, and in the Southern District of Florida, in the Blaze case, the district court reversed the bankruptcy court because it had deferred to the IRS. And when you make that determination under that law, you have to make a determination sometimes that the entire plan is no good, and that it is disqualified. That's what was done in the Blaze case, where you had bad loans. And then it has been done in several other cases in Florida. I believe there was a Fernandez case, and indeed the basis of the decision in the Youngblood case, which is the one they rely upon the most, was not overruled, but was distinguished by the Fifth Circuit later, when in the case of In Re Matter of Plunk, which we have filed a supplemental authority on, there the defendant had used plan assets to pay personal bills, and the trial court had I believe said that they could not go into the plan, but they were reversed by the Fifth Circuit, saying that there was a difference between Plunk and Youngblood situation, in which the Youngblood situation had occurred shortly after the IRS had already ruled upon the same activities. In Plunk, all there was, like here, another initial determination letter, which really doesn't mean very much.
Let me change the facts of this case just a little bit.
Sure.
Suppose that the IRS letter did not exist, the initial provisional qualifying letter, and suppose we had the same rollover and creation of this corporation that we have here, and you go along and somewhere down the road the IRS weighs in on it and sends a letter saying, you know, I think this is, maybe by request or otherwise, they get wind of it and say, I don't think this is a qualifying plan, you haven't done this. The provisional letter goes the other way. In other words, it says, I don't think this does qualify. This is not, the way you set this up, you do not have a qualifying plan. Would your opponent be able to go into state court and challenge that?
No. The IRS would have the last say-so on this.
So why is that different?
Well, it's different because the IRS is not going around actively auditing everyone's plan any more than they are actively auditing all of our tax returns. I mean, sometimes you do, sometimes you don't, but there's no indication in this case whatsoever that the IRS took a second look at this plan, and the initial determination letter doesn't really mean anything. It says on its face that it cannot be relied upon to argue that the plan complies with Section 401A. So, you know, the IRS can determine it, but that doesn't mean that the state court doesn't have jurisdiction to determine it.
So if everything being the same, if the letter, suppose the IRS letter said, no, we don't think this qualifies, but they go ahead and do it anyway. They take their chances. Could they then later challenge that ruling in state court?
No, because it's a federal supremacy doctrine.
Why isn't it in this instance? Why can you challenge it and they can't? Why can you challenge the other result?
It doesn't mean that the state court doesn't have jurisdiction in the cases that I've cited, and I hope I'm answering this question right, the way you've asked it. It means the state court does have jurisdiction, because if it didn't, that you couldn't operate at all, state courts couldn't operate at all under Section Chapter 222, because that's the consideration they have to make is as to the validity of the plan. But if they make that decision and the IRS has not ruled upon it, it's fine. But that doesn't mean that it can go the other way. They couldn't overrule the IRS, which is what is suggested was done here, but was not done. But the case law that's in the brief clearly shows that state courts, not only bankruptcy courts, but circuit courts, are construing these provisions to determine whether a plan is valid. And in this particular case, it was held not valid, and the consequence of that was that this rollover never really occurred. It was void.
Letter rulings, though, are not always sought for these plans. It's sort of a good thing to do. It's a better practice, and many times they're not sought at all. And I could understand why a trial judge sitting in a probate capacity might be able to address this in the absence of a letter ruling. But because you have the authoritative federal agency speaking to this issue, it's almost, to me, it's like a supremacy type argument. I mean, I don't know how, I just don't understand how a circuit judge overrules the IRS. It would seem to me that maybe what should have been done is maybe, you know, bring in the IRS and ask them to take a position on this. I really have difficulty with this, you know, and again, if there was no position they took, I could understand your argument. And I don't recall that any of your cases have this exact scenario where the IRS has actually issued a letter, taken a position, and a state trial court has said, no, I disagree. I'm overruling the IRS on this one.
Well, certainly that's the factual scenario in the bankruptcy cases, which I cited to the court, the Blaze case and the Plunk case. And of course, the bankruptcy court there, even though it's, you know, it's a federal court, it's not an Article 3, I guess it is,
well,
court, and it doesn't have the ability to overrule the IRS either. The IRS, and that's what is stated in the Youngblood decision. They can't overrule what the IRS has just decided, but if in Plunk and in Blaze, if the IRS has done nothing more than issue this initial determination letter, which goes to it with a presumption of correctness. The letter, when the IRS sees that letter, there is a presumption that these people that are filing this plan are doing so in good faith. But the IRS tells
those are all bankruptcy court cases, aren't they? The ones
those are bankruptcy court cases. Those are bankruptcy court cases, but it's not, to me anyway, it's not meaningfully different than what was done in Deeb, except in Deeb you were only talking about one fund. There was no attack on an entire plan, but in this particular case we're really talking about one fund too. We're talking about the IRA rollover, whether that IRA rollover is exempt because of the way the plan was run. So, I mean, you either have jurisdiction or you don't have jurisdiction. If you don't have jurisdiction, I don't think that you would under Chapter 222 either, because Chapter 222 specifically states in it that a procedure whereby you can attack the validity of a plan and you know, indicates that might come before the court. So I think that I believe you have jurisdiction. I mean, I don't know. I've made my best argument.
I got you.
So,
it's not a case we see exactly every day.
Well,
that's why we have all these strange questions.
I understand that, and
I don't see any state court cases that give me guidance.
And
our case indeed looks to the fact that the same result had occurred in a number of bankruptcy court cases.
Right.
That it's a very simple issue, really, whether the inheritance changes the character of the IRA, and the court concludes that it does. I think rightfully so, and it's not a very difficult opinion to understand or to have written, I wouldn't think.
But what it does
has more to do with creditors' rights, it appears to me. Yeah.
Correct, but there's not really I don't think from a standpoint of what is considered, it's not really any different whether it's a creditor or whether it's in probate, where you're talking about whether an asset is an asset of the estate. And probate courts have great vast jurisdiction to determine what is and what is not in an estate. And this was just another circumstance in which it came in, and I would submit this is not a closed case when you get to the facts that were not in dispute about what happened with this company. This company did nothing. It's suggested that there were some tax returns done within this business, but I don't think the record really supports that, because the business made no money. And since both the tax code and ERISA says that in order to be a qualified plan, you have to be engaged in commerce, this plan clearly was not engaged in commerce and failed. And even at the hearing, the counsel for Mrs. Rudin candidly admitted that when asked by the judge. It was never a legitimate plan. There was a question earlier about why somebody would want to do this instead of just leaving it in your IRA. Well, this was known as a pension rollback, and the idea of a pension rollback is to try to defer that date when you have to start taking money out.
I see.
And in this particular case, that was, I think, what was done, because the distributions to the best of what I saw in the record and looking at the Form 5500s did not start coming out until after the man was dead. And those tax returns also were not filed until after the man was dead. So there was this, this plan is not being attacked because of its structure. The way it was structured was legal. It is being attacked because of the fact that it never really had a host to support it. And that's also one reason, to answer another question as to why the plan was never filed. It wasn't really anything that we were particularly concerned about. We had the Form 5500s, which have summaries of the plans and talk about eligibility, and that was important to us because of the fact that neither one of these employees, so-called employees, were really employees, because they had not completed an hour of service in any year. And so we put in the Form 5500s, but we didn't have to, I don't believe, put in the plan itself because it was not being structurally attacked. I think I've answered the question about the joinder of the IRS.
Is there anything in the record where anyone's tried to compute what's going to happen if you're successful?
No, that's not in the record. That's
Okay.
I mean, what you've heard today and what's in the brief, that's the only
Because by the
place.
time the taxes are paid and so forth, it just, I don't know if there's anything left to fight over, but I won't go outside the record.
I would say it's unpredictable, and I don't know what it is. And that's also the other thing about the plan. Even though the plan is not in the record, it's in the briefs. Not my brief, but it's in the appellant's brief. Long allusions and paraphrasing of the plan. It shouldn't be in there. You can't have it both ways. You can't go to the trial court and say, Your Honor, you can't rule on this because there is no plan in the record, and then tell the trial court at the same time what's in the plan, and then take an appeal based upon the plan not being in the record, and then tell this court what's in that plan. So that's, I mean, I've never been in this situation before where that sort of thing has happened. The other thing that I wanted to address briefly is these affidavits. The affidavits, if you look at the affidavits, you see the affidavits don't really say anything. They are just as to two of them, they're just the conclusions of the people that are making them. But Attorney Michael Lloyd, whose firm drafted the plan initially, his affidavit just says that they filed and got a preliminary favorable determination. That's all it says. So that's fine. We don't disagree with that. Mrs. Rudin's affidavit says that that her understanding is that the plan is a valid retirement plan, and and she also opines that it complied with IRS code operationally over the terms of its existence, and that there have never been any compliance errors noted. And none of these things really go to the point of our motion for summary judgment, and that is that the business was not a valid business that could support this plan. And the same with the last affidavit, which is Mr. Nye's affidavit, who was involved with this company that was selling these pension rollbacks, and he says in his opinion it was a valid plan. Well, that's his opinion, but I don't think it meets muster under Daubert or even Fry or any kind of estimation that somebody can just stand up and give an opinion about something without giving any basis for it. Well, I think that we pretty much covered the waterfront here, and I hope I have answered all of your questions. I've tried to, but some of these, as you know, are sort of issues of first impression. I would just submit that at the heart of all this is that in order to be an ERISA plan, a valid plan, a company must be engaged in commerce. ERISA says that. And in this particular case, this company was not engaged in any commerce, and the probate court therefore was correct in holding that this was not a qualified plan, and that this rollover that went into the pension, this alleged pension plan, is an asset of the estate. Thank you very much.
Thank you.
If I may, I don't mean to make light of a serious situation that we have here, but I agree with the court. Mr. Thomas and I have had a very interesting time here dealing with some unusual issues, and it has been certainly, to a certain extent, enjoyable and challenging case.
Well, it's been, we're fortunate to have two good lawyers address this novel issue and brief it very well, so we do very much appreciate your effort.
I appreciate that.
I even appreciate it more if before we have to write an opinion, you have settled it.
Well, Judge, I did take the other case off of the calendar this morning.
And I won't take that time against you for my case.
In my AAPS case, I think we've got that one resolved. Just if I may, just briefly address some of the issues at 1301 of the record. The form annual return, the 550 return was filed and signed. That one is at least a 2003 form that was signed back in 2004. So the actuaries were certainly doing all of their work on this. One of the issues that really hasn't been addressed is what we've pointed out in our papers is, let's assume that there are some issues regarding the operation of the corporation. Typically, those aren't grounds for disqualification of the plan itself. And those are typically addressed by the IRS with an admonishment: this is what needs to be done, changes need to be made. You as the entity and the plan itself are given an opportunity to address those. To the extent that there would be problems, or issues, maybe those are addressed with a penalty, but not simply throwing the entire plan out. Here, again, the plan was established in 2002. It was going under the guidance of the IRS's letter. We recognize that the letter was a qualified letter, but we believe that the evidence in this case shows that the entity was certainly started with the best of intentions, and that it met the minimum qualifications. And again, if it didn't, that's really something that should have been, if it's in fact a sham, that should have been brought up to the IRS as opposed to putting the burden on the Sarasota probate court judge to try to interpret this myriad of Treasury regulations, which I've asked for help from people in my firm because it's a bit over my head.
We have mentioned, and I apologize for the late notion, the notion of federalism in this case about the IRS. Is there any suggestion or any arguments that were preserved that the actual notion may be federal preemption, that they have preempted this field and therefore you would have to stay within it, rather than the superiority of federal to state? There are areas where the federal law preempts the field and states are not allowed to litigate in that area, they're not allowed to pass laws in that area. Does anybody raise any issues of federal preemption, or am I totally off the reservation on that idea?
I believe that I raised that before the lower court and certainly argued that.
I'll check it out.
Here on the appeal, that, you know, and we've cited the Burnett versus Harmel case, that the exercise of the power to tax is not subject to state control. Legislation is to be interpreted so as to give uniform application to a nationwide scheme of taxation. You know, what we have is a situation where potentially there could be a ruling by a judge in New Jersey regarding the effect of the plan, and another one in the state of Florida. What's happened right now is that the plan is still in existence. And, you know, we've also cited to the court the Bosch case, which is a United States Supreme Court case where essentially the federal government takes the position what a state court does doesn't have an impact on the taxing authority. We may look at that, but we're not bound in any way by that. I mean, I've had probate cases that I've litigated before where we've tried to get those all the way up to the Florida Supreme Court because maybe they would look at the Florida Supreme Court on that issue, but they certainly wouldn't look at a lower court decision. And, you know, again, that's the problem that we have here. There's just a lot of confusion about where we go. It's our position that the Florida probate court does not have jurisdiction in this matter. If the court rejects that argument, we contend that there is sufficient evidence in the record to raise an issue of material fact in dispute as to whether or not this corporation complied and plan complied with the IRS regulations. If that fails, we've contended that under federal law, which must be employed here, that we must look at the plan itself, and under the plan itself, it provides that the funds go to the wife as the beneficiary. And even if we don't go to that, we look again at state court, which is, it was clearly Mr. Rudin's intent to create a trust. It was a written document. He created that trust. Certainly there's a presumption he read all the terms of the trust, and we must be bound by that trust. Thank you very much.
Thank you. Thank you both, counsel. And I will borrow a verse from an old song, and the beat goes on. We're going to recess, change our panel, and come back, and I think we'll be at our last configuration.
He's down here on stage.
Oh, never mind. We'll just be an operational recess. Go ahead. We're going to let the judges switch, so we won't have to go. Let you gentlemen leave. And
hopefully Mr. Thomas and I can get into our office. We practice in the same building, the SunTrust building. We received a notice that we weren't going to be allowed in unless we had a specific purpose that we could cite because of the president.
to facilitate the conversation, we'd like to get you a room here. Just trying to be helpful. The next matter is McHale et al., City of Sarasota.